Relations Board. Mr. Grimaldi for the petitioner, Ms. Jihi for the respondent.
Good morning.
Good morning, counsel. Please proceed.
Thank you, Your Honor. If it pleases the court, as we said in our principal brief and our reply brief, the decision here should be overturned. While we were pleased with the underlying decision in regards to a finding that there was no violation of the National Labor Relations Act with respect to the discharge of a particular employee, the remainder of the decision is lacking in many respects. The first thing that I'd like to point out to the court, and it's been characterized as harmless by the board, but it's far from harmless, is their decision to wrongfully admit a collective bargaining agreement. And to me, when you have a National Labor Relations Board case, a collective bargaining agreement is the equivalent of a statute or a regulation or a mandate that you're trying to argue doesn't apply to you. The hearing had closed. The general counsel at the board never put the CBA in. That was a calculated decision. It wasn't hidden away. It wasn't some foreign document that was unavailable. It was a calculated decision. We submitted post-hearing briefs to the judge. We squarely said no collective bargaining agreement. There should be an adverse inference. And rather than agree with our decision, the administrative law judge essentially corrected the general counsel's calculated decision and allowed the collective bargaining agreement in. We had no opportunity to cross-examine anybody from charging party, and we could have probably used the collective bargaining agreement to show that the charging party's terms did not apply to the work that's in question here. Now, you may say, well, why didn't we put the collective bargaining agreement in? Well, why should we? I mean, this is something that should have been the job of the National Labor Relations Board.
But if the board found that it was error and said it wasn't going to rely at all on the collective bargaining agreement, so long as if we find that the board did not in fact rely on the collective bargaining agreement in any of its rulings, then why, how are you harmed?
Well, it smacks of fairness. That's the first thing. The second thing is, if I had that collective bargaining agreement in my hand and they had put their witnesses on, I probably would have been able to show the judge that it just didn't apply to the particular evidence. It's essentially it's a tree that never grew. It could have been all sorts of fruit that it came from it if we had the opportunity to have that agreement there. It was a calculated decision. I believe that you cannot, well, the court could do whatever it wants, but I would argue that you can't have this type of violation being found by the board in the absence of giving us the opportunity to, at least in fairness, have the opportunity to argue that the collective bargaining agreement was essential to their case. They didn't make a prima facie case. And by the way, they amended their own board rules so that this doesn't ever happen again. That's how bad this violation was. We could have used, by the way, the collective bargaining agreement is not even a New York Paving collective bargaining agreement. It's a collective bargaining agreement that's an employer association agreement. I could have asked anybody who they put on the stand from charging party, how is it applied to Trimacine? How is it applied to NICO? These are two companies that do the type of work that New York Paving does. And we'll never know.
You could have asked those questions even if it wasn't in evidence. I mean, the board basically follows the federal rules of evidence, and you can cross-examine someone about a particular document, even if you don't put the document in evidence. So why were you, come back to the question that Judge Wilkins is asking. I don't see how you were prejudiced at all.
Your Honor, with all due respect, I would argue that the collective bargaining agreement is the cornerstone to them arguing that we should have bargained in good faith. If you're going to say that this is Local 175 work, where's your basis? Your basis is the collective bargaining agreement. The collective bargaining agreement is more than just an email or a letter. It is a foundational document that establishes the relationship between the two parties. That would be my answer. And yes, we did try to bring in other evidence. I think we were very persuasive in bringing it. That goes to other points in our appeal.
Can I ask you, Mr. Grimaldi, about, part of your argument is that you were not able to negotiate with Hallen over the contract that was ultimately formed. And I'm wondering, can you tell me a little bit about how the bidding process with Hallen worked? So when you put a bid in, I think New York Paving's position is that you weren't aware of the terms that would be in the contract, and then you received the contract in January. So I was wondering I'm just wondering, sometimes with a bidding process, you're required to accept a contract if your bid is accepted. So if you could just tell me how the bidding process worked.
The way it was in this case was, first of all, just to take two steps back, we're a union shop. We have a lot of unions that work for us. We give a lot of work to 175. We're talking about a tiny little fraction of work, and that fraction of work was covered by the Hallen contract. And the Hallen contract, these are big players, just like Con Edison is and National Grid. If you know anything about the New York City area, it's something comparable to the fact that if I wanted to do oral argument today before all three of you, no, I basically had to participate via Zoom. Hallen used us in the past. We did contract work for them. We used 175 work. We didn't think the 175 would be an issue because they let us do it in the past. And now this time they came in with the contract. It's in the record. I think it's A302, if you want to find where the clause is. And they said, this is what you had to use. You had to use members of a particular, who were members of the buildings council.
I guess if you could answer my question, though, I'm not sure, did you have the ability to negotiate after they had accepted your bid? No,
it was basically, here it is, take it. If we didn't take it, they would find someone else to take it.
Or were you required to take it once your bid was accepted? I'm not sure what the terms of the bidding was. I think that is potentially relevant to some of your arguments, but I didn't see anything about the bidding process in the record.
To my knowledge, it was a take it or leave it. I mean, these are big players. If we didn't agree to use the local 1010 workers for that particular work, the contract just wouldn't have been given to us, because Hallen was required now to make sure their subcontractors use unions that were part of the building trades. And for the life of me, I don't know why Local 175 doesn't become a member of that particular organization. I mean, this case is so upsetting because of the CBA, and also the fact that Local 175 does not want to be part of an organization where the Hallen expects you to be part, to use members of that association. I think it was a take it or leave it, Your Honor. We also believe that the board woefully failed when it came to the substantial evidence, when it came to the 6-month statute of limitations argument we made. I mean, it was so clear and obvious. These Local 175 shop stewards are at our yard. They see trucks going in and going out. I mean, it's the equivalent of someone who normally plays football seeing helmets and pads and footballs going out. You know they're going to be playing a game of football. It was seen by, we have emails, we have testimonial evidence, and the board made short shrift of it. They didn't address it in any meaningful way. And we believe that they had knowledge as far back as April of 2018, and they waited until January of 2019 to file their unfair labor practice charge. I believe, based on everything I've read in its totality, that initially they didn't see that as a violation. They thought it was covered under the regulations that were now in effect. There was a favorable Section 10K decision from the board itself, which gave a portion of the asphalt work to Local 1010. Even their own union attorney, Chaikin, said in a prior hearing he thought that this type of work was basically related to concrete work. I mean, if you're going to cut into a sidewalk, there's no such thing as an asphalt sidewalk. It's a concrete sidewalk. We're talking about a very thin layer of asphalt on top of a sidewalk or in a street. And somehow they must have thought otherwise, and then they filed too late in January of 2019. I see that my clock is done for my 8 minutes.
All right, we'll hear from you on rebuttal. We'll hear from the board.
Good morning, Your Honors. Barbara Sheehy for the National Labor Relations Board. I want to just touch on a couple of things that you were speaking with my opposing counsel there. But the first thing I want to talk about is Judge Rao asked about the bidding process. And I think Your Honor is absolutely correct. There is nothing in the record. There are a lot of assertions that it was a take it or leave it contract and references to, I don't think there's any dispute that these are big players in the New York construction industry. But I think what is the most relevant point is rather than speculating, was it take it or leave it? I think it was because these people were these kinds of construction guys. We know there is nothing in the record that New York Paving had to accept the contract and could do nothing with Halen. And in fact, I think a very important point in that regard is that the New York Paving, the company says they were surprised actually when the terms came in, because notwithstanding the fact that Con Ed had required this Building Trade Council membership before, it had never been enforced. So they were under, and so Halen had allowed Local 175, a non-member, to do work even under a Con Ed contract. And so so you could speculate further that it could have been take it or leave it, or it could have been that New York Paving, had they tried to go to Halen and say, hey, listen, I see this new term in here. You've let us in the past slide on this. Any chance we could negotiate 6 months grace period or 12 months or anything? There's nothing in the record that.
Well, actually, Ms. Sheehy, what about under the general terms and conditions, which is on the appendix of page 264? It says for acceptance of the contract, the subcontractor may accept this agreement only by signing and returning it to the contractor without modification within 3 days. Does that suggest it's a take it or leave it contract?
I don't believe so. That's in my understanding of contract language. I don't think that that's an unusual aspect to have in there. And I don't know that we know, for instance, I think that's standard language in a contract. And I don't think it's fair to say that under no circumstance, that all the time, that means no modifications. We know that parties can modify terms. We know that the lawyers have drafted them up and tried to make them airtight. But at the end of the day, no, I don't know that there was any evidence that somebody tried or somebody read that and said, we didn't think we could do anything. What the testimony was Maselli said they got the contract sometime in early January and they signed it. So you have knowledge of the terms and at the time of signature, because it wasn't executed until January 9, and you have at the time, they know they have an existing contract with Local 175, even in this multi sort of employer thing. So you have an employer that knowingly executed a contract that put it on contrary terms with an existing contract. I think that's the fundamental. That is what the record shows. The record doesn't show that it was a take it or leave it. Certainly there are aspects of a take it or leave it in that agreement, like Your Honor just pointed out. But as I said, there are elements that are completely missing too in the record that New York Paving didn't even try. Pick up the phone and call Halen and say, hey, I see there's no modification.
doing burglaries, much less that there was going to be a murder. But what the court said was that she knew something was afoot. She knew something illegal was afoot because there's all this money that's being made, and her turning a blind eye to it, not asking questions, was enough for her to be held liable for aiding and abetting that murder. So that's why we believe that the broader legal rules should apply. But Your Honor, we think that our pleading fits under even the narrower rule.
Sir, if we accept your broader formulation of the rule, as you're calling it, would that create a circuit split with the Second Circuit?
I don't believe it would under Kaplan, Your Honor, because even though what I'm saying is the broader rule, you have to be within those riverbanks of the broader rule, but you still have to apply the other Halberstam factors, and that's why it's kind of an overall qualitative analysis. So if we look at the Kaplan decision in the Second Circuit, one of the things they said was that these weren't routine banking services. The appellees say in their brief that these are routine banking services, but they weren't. They were violating a sanction scheme designed to prevent terrorism. That's one thing. The second thing that happened in Kaplan in the Second Circuit was, even though there was a UN report linking the Lebanese Canadian bank customers to Hamas, they continued, they poo-pooed that report. They said that's just propaganda, and they continued to do business with them. And that's essentially what happened here with HSBC and Al Rajhi Bank. Despite these public reports, despite their own database saying we should stop doing business with them, despite the fact they stopped doing business for a year, then they started back up in 2006 doing business with Al Rajhi Bank and did business all the way through the terrorist attacks at issue here. So we think that this case would fit the parameters of the Kaplan case in the Second Circuit and is distinguishable from the Siegel case, which didn't involve sanctioned banks like the Iranian banks. And therefore, we think if you were to send this back and in reverse, it would be very consistent with the Second Circuit's ruling in Kaplan and in Siegel.
So you think that the facts are distinguishable?
We do think yes, Your Honor, because in Siegel, it was HSBC defendants, but in Siegel, the only allegations were with regard to Al Rajhi Bank. And in Siegel, what the court said was most important in Kaplan, when it distinguished Siegel, the court said what's most important is that HSBC stopped doing business with Al Rajhi Bank 10 months before the attacks that were at issue in Siegel. But then what happened is, after the attacks at issue in Siegel, they started doing business with Al Rajhi Bank again and did $1 billion of banknote business with Al Rajhi Bank before our attack. And so we think that the facts are distinguishable from Siegel, and we think that the court's ruling, if it were to reverse, would be entirely consistent with the Second Circuit. Your Honor, the other main issue with regard to the district court's opinion is that when the district court analyzed the Halberstam factors, it only looked at direct connections between the defendants and the terrorist group Al-Qaeda or Balawi. And that's just inconsistent with the purpose of JASTA. The Anti-Terrorism Act was amended by JASTA to allow for the kind of indirect liability that we're advocating for today. And so we believe that if you look at the allegations in the complaint under the standards of JASTA as it amended the Anti-Terrorism Act, that we fit well within the parameters of that based on the amount, 10 years. They were doing this, HSBC was doing this, the amount up to $19 billion, the time and the nature of the terrorist attack and the state of mind of HSBC. Your Honor, I see that my time is up. I'm happy to answer any other questions, but I'll save the rest for rebuttal.
Judge Randolph, Judge Rao?
No.
Okay.
All right, we'll give you some time on rebuttal. We'll hear from counsel for HSBC.
Thank you, Your Honor, and may it please the court. Defendants abhor the terrorist acts that injured plaintiffs, but the complaint here fails to allege facts permitting plausible inferences of any of the elements of either aiding and abetting or conspiracy liability under JASTA. And let me start with Judge Rao's question about a conflict with the Second Circuit. We think reversing here would create a conflict because this case is really indistinguishable from the Second Circuit's decision in Siegel. Siegel, as my friend on the other side acknowledged, involved the very same allegations about dealings, clearing transactions, dollar clearing transactions with Al Rajhi Bank. And what the Second Circuit said in the Kaplan case, in which it held that the complaint was sufficient in distinguishing Siegel, where the dismissal of the complaint was upheld, it said, and I'm quoting from page 862, there are conspicuous differences between this case and Siegel as to the customers that were served by the respective banks. In Siegel, HSBC's relevant customer was another bank, ARB, Saudi Arabia's largest bank with vast worldwide operations. And ending the quote, the court went on to say that in Kaplan, the defendant directly banked as its customers the alleged terrorists or terrorist fronts. So what the Second Circuit has done is drawn a distinction between clearing transactions for other banks that have legitimate functions and cases where the allegation is the customer was a terrorist.
Right. So, but Mr. Pincus, so here at least Bank Saderat was a specially designated global terrorist group, right? So it's not just Al Raji Bank, which doesn't have that designation. I mean, here, the United States government has designated that bank as one, that poses a significant risk of, doing financial transactions with organizations that have committed or are expected to commit terrorist acts. I mean, isn't that a more direct connection?
I don't think so, Your Honor, because it still was a bank with legitimate functions, and courts have said even dealings with Iran itself, and the allegation here is that those two banks were controlled by Iran, is distinguishable because governments, even Iran, have legitimate functions. And so I think the distinction here, these banks fit into the same category as Al Raji Bank. It's the distinction that this court drew in the BNP Paribas case, albeit in the proximate cause connection, where it drew a distinction between the bank dealing with Iran, which is a government with legitimate functions. So I think here these banks are in the same situation and therefore fall into the same category.
They may well have some legitimate functions, but the U.S. government has said we are going to place sanctions on them because of their terrorist affiliations. And then if HSBC helps them to evade those sanctions, I mean, isn't there a connection there? Is that connection not sufficient for at least aiding and abetting liability? If not,
I don't think so, Your Honor. I don't think that's the standard here is with HSBC generally aware that it was assuming a role in terrorist activities. And I think to meet that high standard, which is a high standard, I think, just dealing with a bank that has legitimate functions, but also may be involved in some illegitimate activity, that's exactly the same allegation that's being made here in the complaint about Al Raji Bank, that it was a bank that had legitimate functions, but that it also was banking terrorist activities. And because Siegel found that wasn't enough for Al Raji Bank, it shouldn't be enough either for these banks, because it hasn't been found enough even for dealing with Iran itself in other cases. I'd like to address, if I may, the legal question of what's required. Mr. Singer said, pointing to Halberstam, that all is required is an awareness of assuming a role in wrongful conduct from which terrorist acts are foreseeable. And I think that is inconsistent with the statutory language here. What the statute says is it imposes liability, and I quote, on a person who aids and abets by knowingly providing substantial assistance, and then deleting the words relating to conspiracy, such an act of international terrorism. So it expressly creates aiding and abetting liability for aiding and abetting international terrorism. Halberstam was different. It was talking about general aiding and abetting standards, and therefore said, as a general matter, aiding and abetting liability can attach for any foreseeable wrongful act, any foreseeable injury resulting from the wrongful act aided. But here Congress was very specific. It created a specific form of aiding and abetting liability. It didn't say there's liability for aiding and abetting any wrongdoing from which an act of international terrorism is foreseeable. It did not say that. It said aiding and abetting an act of international terrorism. And therefore we think the general awareness that's required here is assuming a role in terrorist activities.
So let me ask you this, Mr. Pincus. Suppose you have three people and person one says to person two, I'm really sick of my boss. He's been mean to me and didn't give me that raise. I'm going to shoot him. And knowing that person two says to person three, hey, let me borrow your gun because I want to give it to person one because he needs it to take care of his boss. And person three gives his gun to person two, and person two gives the gun to person one, and person one shoots and kills his boss. It sounds like me that you're arguing that person three can't be convicted of aiding and abetting liability on those facts.
I don't think I am, Your Honor, because if we're talking about general awareness, person three certainly had awareness that he was, by giving the gun to person two, who said he was going to give it to person one to commit the murder. I think the person three, unless I'm misunderstanding your hypothetical, would have the requisite general awareness. We're not making.
You're saying that the statute says you've got to directly aid the principal.
No, I'm making a different argument, Your Honor. I'm not saying that the statute, neither we nor Judge Kelly said there had to be direct aid. What I'm saying here is that the awareness has to be awareness of assuming a role in terrorism. My friend on the other side has said that the awareness just has to be awareness of any wrongdoing from which a terrorist act is foreseeable, and we think that is not consistent with the statutory language. That doesn't have to do with directness, which is a different question. Where directness comes in, and I think my friend is wrong that Judge Kelly applied a directness standard, is one of the 6 substantial assistance factors is how direct the relation to the principal, how direct the aid is. One of those 6 questions does ask that, and here it's quite indirect. And so that indirectness, as one of those 6 factors in your example, could weigh against finding aiding and abetting liability, finding substantial assistance, depending on the other factors. Here, we think all of the factors weigh very strongly against finding substantial assistance. That the nature of the act encouraged here at most, as Siegel said, the act encouraged was not terrorism, it was assisting in the regulatory violations. The amount of assistance, as Siegel said, put a low weight on that, because as in Siegel, as here, there's no allegation that any of the money actually went to a terrorist group. There's no allegation of that in this complaint. Third factor, presence or absence at the site of the wrongdoing. Again, none of the HSBC defendants were present at the terrorist acts. Relation to the principal, as I've said, here, there is no direct relationship. It's quite an extended chain. HSBC to the Iranian bank, to their customers, to the Iranian government, to Al-Qaeda, quite an extended chain. And the Second Circuit in the Honickman case, which came after Siegel, said, and I'm quoting from page 501 of that opinion, said that the relation, quote, should not be so attenuated as in Siegel, and picking up the quote again, where a commercial relationship with another bank that was linked to various terrorist organizations, including the FTO that caused the plaintiff's injury. So the Second Circuit has said critical here that there's that extended relationship. State of mind, the defendant wasn't of one mind with the wrongdoer. Again, Judge Kelly didn't require specific intent, but in applying this factor, he said there wasn't that intent, and that weighs against finding substantial assistance. And then there's duration. The duration of the relationship was long, but again, as the Second Circuit pointed out in Siegel, there's no allegation that any of the money actually went to the terrorist groups, and so that weighs against that factor. So I think if you look at all of those factors, there's a very strong argument that these cases aren't compatible. And just to anticipate one other statutory argument that my friend may make and that's made in the briefs, is pointing to the purpose, findings and purpose clause of the JASTA. And I think it's important for the court to look specifically at the language, because if the court looks at 2A, 6, and 7 of the findings, I think he'll find that that directly and indirectly language in 7 relates to personal jurisdiction. Congress was concerned about the scope of personal jurisdiction. And so after saying Halberstam is the substantive test, it had some findings related specifically to specific jurisdiction. And then the purpose clause talks about the purpose of the act providing civil litigants with the broadest possible basis consistent with the Constitution of the United States to seek relief against persons, et cetera, et cetera. So we think it's quite clear that that purpose doesn't override Halberstam or the statutory language, but is focused on Congress wanting to be sure that the courts of the United States were open to the greatest extent possible, given that a lot of these defendants would be found outside the United States. I see I'm over my time, unless the court has any further questions.
Judge Rao, Judge Randolph?
No.
All right, thank you, counsel. Did counsel for appellant have any time remaining?
They did not, Judge.
All right, we'll give you 2 minutes for rebuttal, sir.
Thank you, Your Honor. The et cetera, that my friend just mentioned, it goes on to say directly or indirectly supporting terrorists. And I think that's really what this case is boiling down to. If you look at the opinion below, my friend said that the judge did not require direct support, but at Joint Appendix page 88, it says the plaintiffs do not allege that the HSBC defendants had any involvement in transactions that the banks performed directly for Al-Qaeda or others involved in the attacks. And at page 89, Judge Kelly said the plaintiffs make no allegations that the HSBC defendants had any direct relationship with Al-Qaeda or Balawi. So at every factor, when the Judge Kelly was analyzing the Halberstam factors, the judge looked only at direct involvement. In the statute,
all of the transactions here were bank to bank, isn't that correct?
The transactions were, yes, Your Honor, bank to bank. And the difference between the transactions here and the transactions in Siegel, and that's why the Second Circuit Siegel and Kaplan opinions are so important, is because in Kaplan, the defendants made the same argument that the appellees are making here. These are commercial bank transactions, and therefore we can't be held liable for commercial bank transactions. But what the Second Circuit said in Kaplan,
under your theory, would it be so that any depositor in the Raji Bank is potentially liable under the statute?
No, Your Honor, because under our theory, it's not just Al Raji Bank in routine commercial transactions. It's violating sanctions designed to stop terrorism with the Iranian banks who were themselves specially designated terrorists. That's what makes this different from the Siegel case. And the court in Kaplan distinguished the Siegel case as well. Its own circuit has distinguished the prior Siegel case, saying, we never said that just because these are commercial transactions doesn't mean there's not liability. And the court said in Kaplan, what we have here is that the Lebanese bank in Kaplan violated international norms by giving these 5 customers preferential treatment. So the court said, these aren't routine commercial transactions that are going on here. And that's what we have in this case, Your Honor, is these are not routine commercial transactions. We keep hearing that phrase, but the fact is every time they dealt with Bank Melli and Bank Saderat, they were violating US and international sanctions laws. And to say that terrorism acts are not reasonably foreseeable when you're doing financial business with banks that have themselves been sanctioned because of their support of terrorist activities, we think at least that creates a jury issue and should not be dismissed on a motion to dismiss. Your Honor, I see that my time is up. I'm happy to answer any other questions that the court may have.
Judge Rao, Judge Randolph?
No, I don't have anything.
All right. Thank you, counsel. We'll take the matter under advisement.
Case number 20-5368, Yassin Aref and Daniel McGowan, Kifa Jayusi, appellant, versus Merrick Garland, Attorney General of the United States et al. Ms. Miracle for the appellant, Mr. Sauter for the appellees.
May it please the court, Rachel Miracle from the Center for Constitutional Rights. Along with my colleagues at the law firm of Weil Gotshal, I represent plaintiff appellant Kifa Jayusi. Mr. Jayusi was sent to a communication management unit in 2008, at a time when the Bureau of Prisons had no written criteria for CMU placement and no method for reviewing prisoners for release from those units. Through his 5 years in the unit, he was given shifting explanations for why he was there, what he needed to do to get out, and was explicitly told he had no due process rights. He seeks a ruling that those shifting and inconsistent procedures do not satisfy Hewitt v. Helms' minimal requirements of notice of the basis for designation, an opportunity to rebut that basis, and periodic review. I'll begin with notice. The district court erred for two reasons. The district court ruled that providing a summary of some, but not all.
Before you get to the substance, can you just explain to me what is the redressable? How do you have redressability in this case, right? Because it's your obligation to show that there is Article 3 case or controversy throughout the pendency of a case, and so I'm wondering why his suit is not moot at this stage.
Thank you, Judge Rao. Since the pleading stage, Mr. Jayusi has been seeking expungement of the erroneous and inflammatory information about him that was created through the counterterrorism unit's flawed CMU designation and review procedures. So a request for expungement saves a case from mootness, so long as there is a real risk, a more than speculative chance, that information may harm the plaintiff in the future.
So, what is the harm here?
Here, the potential for harm is that the counterterrorism unit was designed to monitor individuals like Mr. Jayusi and to share information about them with law enforcement. So as the district court held, we already know that the FBI visited Mr. Jayusi after his release from the CMU, asking him questions about his time at the CMU and his current life. We know that the information that the counterterrorism unit holds about Mr. Jayusi goes far beyond what the basis of his convictions. For example, Mr. Jayusi was not found at trial to have used religious training to recruit anyone towards his conspiracy. He was not found at trial to have communicated directly with Al-Qaeda. And yet, because the CMU designation procedures are so flawed, that information is in.
What do you mean it was not found at trial? I mean, in a criminal case, there aren't like special verdicts where facts about going beyond kind of like the elements are found. It's just a question of whether there was evidence that was introduced during the trial that could lead someone to conclude, right?
Well, that's true, Your Honor. Now, the counterterrorism unit states that this information, which appears on Mr. Jayusi's notice of transfer, comes from his pre-sentence report. But we have the pre-sentence report, and it does not say that about Mr. Jayusi in his pre-sentence report. It does say that about a co-defendant of his. And actually, there's been a pattern at the counterterrorism unit of including reasons about individuals who are being considered for designation that, that replicate what has been said about their co-defendants and not them. So, here, Mr. Jayusi's notice of transfer says that he was sent to the CMU based on his crime of conviction and his offense conduct. And it describes his offense conduct as involving providing support to Mujahideen, using religious training to recruit others towards a conspiracy, and communicating with Al-Qaeda. Now, when Mr. Jayusi used the administrative remedy program, which is the only way individuals sent to a CMU may challenge their designation, he used that program to say, this is not part of my conviction. I was never shown to have done this. And the warden who reviewed his administrative remedy at the first level ignored that factual rebuttal, instead saying that Mr. Jayusi's connection to terrorism was shown through his terrorism enhancement, and that he was also sent to the communication management unit based on sensitive law enforcement information, even though nothing like that appeared in Mr. Jayusi's notice of transfer. But
didn't the PSR discuss his involvement with Al-Qaeda at paragraph 11 and paragraph 59?
My recollection of the PSR, and I'll look at the paragraph you're citing to in a moment, Your Honor, is that there's no direct communication with Al-Qaeda. There was information in the PSR about groups that Mr. Jayusi communicated with who themselves communicated with Al-Qaeda, but no communication between Mr. Jayussi and Al-Qaeda itself. You said paragraphs 12 and 13, Your Honor?
I said paragraphs 11 and 59.
Oh, I'm sorry. 11 and...
So you can maybe respond in your rebuttal on that. But I guess even if for the sake of the standing and redressability, we have to kind of assume you would prevail on the merits. If we get to the merits, what I'm trying to understand is exactly what would have been different had you had notice, because the report from the CTU chief did not say that Mr. Jayussi had been disciplined under the disciplinary kind of system for leading the Muslim prayer. It explicitly said that he had no disciplinary record that he had been sanctioned for, but it just described the prayer and said that they believed that that was concerning. So I'm trying to understand, like, what would have been different had he had noticed that he would have responded to and said, well, this is false. And where was that argued in your brief?
Well, two responses, Your Honor. First, on the question of the Jumu'ah prayer service that he led, that really went to the counterterrorism unit's reasons for declining to transfer Mr. Jayussi out of the CMU after he had already been there for a period of 3 years. And our primary argument with respect to the inadequacy of the CMU's review process is that they were untimely. Mr. Jayussi was not reviewed for the first 18 months that he was in a CMU. Bureau of Prisons didn't even have a review process for that period of time. And that once he was reviewed for potential release from the CMU, he was not told what he needed to do to change his behavior. And that gets at Your Honor's question. What would have been different if he had learned that his Jumu'ah prayer service played a role? Well, there were inaccuracies in the way that the counterterrorism unit was describing that service. For example, the counterterrorism unit said that it was an example of radicalization and that his unit team had recommended against his release from the CMU because he was involved in radicalizing other prisoners. This is incorrect. His unit team had recommended initially against his release from the unit because of his crimes of conviction. By the time his potential release from the unit was up before the counterterrorism unit at the 3-year mark, they recommended for his release from the CMU, noting his good conduct and his good rapport with staff. So had he had notice of the reasons, he could have explained that the counterterrorism unit did not have a full picture of his conduct in the CMU. But moving back, Your Honor, to what he was initially told about his CMU placement, he was told that the reasons for his CMU placement included these aspects of his offense conduct that he felt were contradicted by his pre-sentence report. When he pointed out the errors, he received ever-shifting explanations for why he was in the unit. There wasn't a defense by someone in the Bureau of Prisons saying, no, we looked at your PSR and this is correct, or, well, it doesn't really matter whether that was your offense conduct or not because you're eligible by virtue of your crime of conviction. Instead, he was told by the warden sensitive law enforcement information is the reason you're there. Then when he appealed to the regional director, he was given yet another description of what led to his CMU placement. And really, I think the problem here is that there is no way to tell for the record why the decision maker actually sent Mr. Jayussi to the CMU, because the decision maker did not write down his reasons for Mr. Jayussi's CMU placement anywhere. Now, due process requires that an individual have the opportunity to learn the decision maker's reasons. When asked at his deposition why Mr. Jayussi was sent to the CMU, the regional director said, it would have been based on all the information that I got from the counterterrorism unit. It was probably his offense conduct. And that is at I want to make sure I give you the record site for that. That is at JA 1638. So it's clear the regional director had no individual specific knowledge of why he sent Mr. Jayusi to the CMU. So Mr. Jayusi's opportunities to rebut those reasons were meaningless. He was left stumbling towards a moving target. I see I'm out of time, unless your honors have any more questions.
Judge Rao, Judge Randolph?
No.
All right, we'll give you some time on rebuttal.
Thank you.
All right, we'll hear from counsel for the government.
Thank you, Your Honor. Kevin Soder from the Department of Justice for the government. I'd like to begin on mootness and explain why so what's important to keep in mind is that at all previous stages of this case, including the prior appeal to this court, the injury was an injury to liberty. And that injury is indisputably gone from this case. And now all we're left with, as some of the questions we're getting at, is figuring out whether there is any injury that can still be traced to the records that BOP has maintained. And there simply isn't. Everything that is being relied upon by the plaintiff here is too speculative to support the exercise of Article 3 jurisdiction. And that's made clear when you look at the fact-specific inquiry at what these specific records actually reflect and how they might be used in the future according to the plaintiff. And when you try to pair those two together, you end up with just too much speculation layered on top of speculation to support jurisdiction. So
the CMU records are available to whom?
So the plaintiff has requested expungement of a number of records within BOP's possession, including any reference to the fact that he was in the CMU, which appears kind of throughout.
My question is the records themselves, the documents. Are they available to the man on the street? Are they available to state law enforcement? Are they available to the FBI?
So the BOP has a detailed set of processes related to when it can share records with other law enforcement agencies and with probation offices in particular, which are relevant here. And so a request would have to be made or a process would have to be in place for you to kind of conclude that these records end up shared with anyone. And here, plaintiff has only pointed to two ways in which he expects that these records might be used. One is by law enforcement, and for that, there is just no basis to conclude that any records have been provided that would be detrimental to him or will be provided in the future. And the other is the supervised release court, which we know there's a BOP policy about what gets shared with the probation office in the supervising district. And that policy lays out the documents that would be sent, and those wouldn't include, just sort of as a matter of usual course, they wouldn't include things like the notice of transfer that he's alleging mis-summarize his offense conduct, and wouldn't include the internal memoranda summarizing why he was kept in the CMU. And of course, I think it's also important to keep in mind that there's an additional layer of speculation about someone even relying on this information, given kind of factual disputes about the accuracy of it. The due process claim here is primarily, as plaintiff's counsel was discussing, about an adequate opportunity to respond to statements that were made as part of the basis for maintaining the plaintiff in the CMU. And those statements are not inaccurate, but kind of the remedy for that would be to allow the plaintiff to air those responses in, for example, the supervised release proceeding.
Okay, thank you.
I was interested in the government's argument in footnote 7 about whether this court could even order expungement of the records here. Are you suggesting that expungement is not a remedy that's even available to this court? I mean, we have expunged records in the past as a remedy.
So the point we were making there is that there is a specific standard that must be met for expungement to actually be an appropriate exercise of a court's equitable discretion. And here we think we are far away from a situation in which that standard is met, in part because of the disconnect between the due process claim and the records here that we're talking about. This isn't a situation like the court's prior cases in Doe, for example, where the allegation was that the government shouldn't have the records at all, and that was an unconstitutional search claim. And so that's a further reason why it's speculative to think that expungement would end up even helping the plaintiff, is that it doesn't really redress a due process violation.
And Mr. Sutter, could you tell me also, so now there are new procedures for placing someone in, is being designated for the CMU unit. So how do those procedures differ from the ones that Mr. JUC was subjected to?
So in the main, the procedures have not changed. They've been codified at a regulation that states kind of the core requirements that are necessary for due process that have been satisfied here are notice and an opportunity to respond. And they also provide for the additional protection of periodic review at 6-month intervals. Those have been—
That's the main difference, the periodic review?
The periodic review has been in place at least since 2009. There's a policy that's in the record. It's a memo from the Assistant Director for the Correctional Programs Division, and that's at page 975 of the record. So that's been in place since well before the regulation was finalized. Of course, that came into effect shortly after Mr. JUC had been in the unit. So his initial period of his confinement didn't include the specific policy requiring explicit re-examination by the BOP at 6-month intervals. But other than that, the policies have been the same since 2009 and since before that for the notice and opportunity to respond. And I think on the merits, it's important to keep in mind just what the due process clause requires. As this court's previous decision recognized, the degree of process due here is minimal and needs to account for the interests of prison administrators making difficult judgments, predicting who in the prison population is most in need of these additional communications restrictions to ensure that other communications restrictions that might be in place in other units can't be circumvented. And here, the processes that are in place amply satisfy that requirement. To address some of the points that were made previously, I think it's important to see how far away this case actually is from shifting explanations or something where you are unable to respond. If you look at the notice that was given to the plaintiff here, the objection that he made and the response that he received in the record, those show no reasonable dispute that he was placed in this unit because of his convictions, because his offense conduct included communicating in code. You can see that in the PSR at the paragraphs that were being discussed. You can also see kind of the connections to Al-Qaeda at the paragraphs that Judge Wilkins was pointing to, as well as I would point to the 11th Circuit's decision in the direct appeal at page 1105 goes through some of the offense conduct that's relevant there. And it mentions, I think it's also, you can look at the PSR, I think it was paragraph, I believe paragraph 59 maybe mentions communications received from foreign terrorist organizations. I'm happy to address any questions the court has about either mootness or the merits.
Judge Rao, Judge Randolph?
No, I don't have any.
Yep.
All right.
Thank you.
Thank you. We'll hear from counsel for appellant on rebuttal. Give counsel 2 minutes.
Thank you. First, to answer your question, Judge Wilkins, I reviewed paragraphs 11 and 59. Paragraph 11 does talk about Al-Qaeda, but not any connection Mr. JUC specifically had to Al-Qaeda. And paragraph 59 is a connection to someone with a connection, not a direct connection himself. And there again is nothing in the PSR that speaks of Mr. JUC using religious training to recruit anyone toward a conspiracy. Moving to the question of whether the injury in this case is too speculative, there is no difference between this case and Abd al-Fattah, which the district court relied on, except that Mr. JUC has provided more information about how the evidence, the allegations about him could harm him in the future. And it's not surprising that in Abdel Fattah, this court didn't require, specific evidence of how the information could be used against that plaintiff, because it's sort of common sense that when a government agency, especially an agency designed to share information, has negative information about you, that creates a risk of harm. Indeed, in Hedgepath, then Judge, now Chief Justice John Roberts, used this common sense approach when considering that a child plaintiff's request for expungement of her arrest record saved her case from mootness, given that the child would not have to face the possibility in the distant future of answering questions on an employment form about whether she had an arrest record. Now, the child had no pending applications for employment that I'm aware of, nor did she testify that she wanted to work in a field where these kind of questions were answered. Rather, it was a common sense approach about a real risk of harm. Judge Randolph asks about whether the documents are available to the FBI. And I find it notable here that throughout this case, the Bureau of Prisons has never taken the step of getting a declaration from the counterterrorism unit disavowing their intent to share this information with the FBI in the past or in the future, when it would have been quite easy for them to do so. And finally, the new procedures that are at issue in this case, which Judge Rao asked about, notably the administrative remedy program remains the only way that individuals in the CMU can rebut the factual basis for their placement, though not a single individual has ever used that program successfully. Thank you, Your Honors, unless there are any other questions.
All right, thank you. We'll take the matter under advisement.
This honorable court is now adjourned until Thursday, October 21st at 9:30 a.m.